India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring to you latest legal news, biggest and most significant hearings and judgments of the day. We'll also bring you the details of the court proceedings, and before we begin, here's the headline. The Supreme Court observed that Bhima Koregaon accused Sudha Bharadwaj has good grounds to seek bail on merits of her case, declined to entertain her bail plea filed by medical grounds. Delhi court sends Umar Khalid to judicial custody till October 22nd in connection with Delhi riot case. Khalid is under arrest under UAPA. Delhi High Court asked Delhi police to compile data on honey trap cases and file report in 4 weeks, instructs to take action as per law. And Bombay High Court to hear Kangana Ranaut's office demolition plea tomorrow turns down BMC request for more time, said you were in no hurry to tear down the building.
India Legal presents Courts Roundup.
The Supreme Court has dismissed as withdrawn as a plea filed on behalf of Sudha Bharadwaj, accused in the Bhima Koregaon case, seeking interim bail amid the COVID-19 pandemic. The Supreme Court observed that Sudha Bharadwaj has good grounds to seek bail on merits of her case, while it declined to entertain her bail plea filed on medical grounds. A bench of Justice U. Lalit and Ajay Rastogi heard a plea against the Bombay High Court order which had dismissed Bharadwaj's earlier attempt to get interim bail on medical grounds amid the pandemic. Appearing for Bharadwaj advocate, Vrinda Grover sought interim bail on the ground that her client was suffering from diabetes and other comorbidities. Grover said that while spending the last 2 years in jail, Bharadwaj had developed arthritis and a heart condition. When Justice Lalit noted that the High Court order stated that Bharadwaj's medication was in order, Grover said, "I only seek your indulgence to get checked. This test cannot happen in the jail hospital." Justice Rastogi then asked advocate Vrinda Grover, "Are you saying this report is false? You have a good case on merit. Why don't you file a regular bail application?" While the court noting the Bharadwaj condition needed a deeper look and that a regular bail plea could be filed, the plea was dismissed as withdrawn. Sudha Bharadwaj has been lodged in Mumbai's Baikola Women's Jail since 2018. She had earlier filed an appeal before the High Court after the special NIA court rejected her bail plea. While holding that no case was made out of interim bail, the High Court noted that the National Investigation Agency, the Maharashtra government and the prison authorities were taking all precautions to prevent the spread of COVID-19 and that she was being given the necessary medical care. The High Court had also directed the Maharashtra government to submit Bharadwaj's latest health report and an affidavit within a week clarifying how it proposed to implement safety guidelines and the court's PUCL judgment in the Baikola prison to protect inmates. On the question of who is liable to pay compensation to employee with expired driver's license in an accident, the Apex Court in its judgment has said that an insurance company cannot be made liable in the event their if there was an expired license held by the driver who was driving his employer's insured vehicle. The Supreme Court has held that liability of compensation cannot be passed in on an insurance company when the driver of a vehicle involved in an accident does not have a valid driving license. The Supreme Court bench of Justices Sanjay Krishna Kaul, Anuruddha Bose and Krishna Murari was considering the question of whether an insured employer would be absolved of liability in a case where his employee drives a vehicle owned by the employer and meets with an accident while holding an expired driving license. In this case, the respondent was gainfully employed by the appellant and had suffered 20% of permanent disability after meeting with an accident while driving a truck owned by his employer. The Supreme Court notes that it has been unable to trace out any precedent laid down by the Supreme Court on this issue. However, the apex court had the benefit of a number of High Court judgments on this aspect of law. It was argued before the court that the employer as an insured had taken due care at the time of employing the respondent to ensure that he held a valid driving license. However, the renewal of the license ought to have been the responsibility of the respondent. It was pleaded by the appellant. The court, however, observed, "We are of the view that once the basic care of verifying the driving license has to be taken by the employer, though a detailed inquiry may not be necessary, the owner of the vehicle would know the validity of the driving license as it is set out in the license itself. It cannot be said that thereafter he can wash his hands of the responsibility of not checking up whether the driver had renewed the license." Having said so, the court also underlined that the claimant in the case, that is the workman who suffered disability, was negligent to the extent of not renewing the license. However, the case before the court was that of the Workmen's Compensation Act and not that of the Motor Vehicles Act, the court added. The court referred to a Delhi High Court judgment in the case Tata AIG General Insurance Corporate Limited versus Akanksha and others, where the ounce to prove that there was no breach of insurance policy was shifted to the owner insured after the insurance company showed that valid license did not exist on the day of the accident. Supreme Court said that it was the responsibility of the employer to ensure that the valid license was renewed when it expired, especially since the workman was engaged in driving a commercial vehicle. Since the instant case is a matter under the Workmen's Compensation Act and not the MV Act, the consequences do not flow to the respondent who suffered the accident and who was also negligent to the extent of not renewing his license. Since there is no third-party claim and no other person suffered in the incident, the respondent was not held liable by the court, which proceeded to dismiss the appeal and effectively upholding the liability fastened onto the employer in the case, who was the insured party and owner of the vehicle. Bureau Report. The Supreme Court has dismissed a frivolous and with a cost plea seeking prevention of suicide at IITs across the country. The court said that the authorities are alive to the problem. The petitioner was fined 10,000 rupees. A three-judge bench of Justice Rohinto Fali Nariman, Justice Navin Sinha and Justice Indra Banerjee listened to the PIL patiently for 10 minutes. Then the bench told the petitioner, "We have heard you fully. The question now is of awarding cost. Since it is an utterly frivolous petition, the petition was filed by Advocate Gaurav Kumar Bansal seeking direction for care to be given to IIT students, citing the high rate of suicides among them. The court said authorities, as evident from petition, are alive to the situation. The PIL is utterly frivolous and dismissed with cost of 10,000 rupees, it ordered. The Supreme Court has held that the notification issued by the centre to increase import duty on goods from Pakistan by 200% in the wake of the Pulwama attack last year could not be applied retrospectively. The three-judge bench of Justice D.Y. Chandrachud, Indru Malhotra and K.M. Joseph passed this order while dismissing the appeal by the centre against a Punjab and Haryana High Court judgment holding that it cannot levy enhanced custom duty from importers who had already presented bills of entry for home consumption before the enhanced rate was notified in e-Gazette. 40 CRPF men were killed in a terror attack in Pulwama in Jammu and Kashmir on February 14 last year. 2 days after the attack, the centre issued a notification under Section 8A of the Custom Tariff Act 1975, which subjected all goods originating from Pakistan to 200% enhanced custom duty. The government's notification was uploaded on the e-Gazette at around 8:46 p.m. on February 16 last year, and the custom authorities at the Land Custom Station at Ataria in Punjab sought to enforce the enhanced rate of duty on importers who had already presented bills of entry from home consumption before the enhanced rate was notified in the e-Gazette. This action was challenged before the Punjab and Haryana High Court, which ruled in favour of the petitioner. The centre had appealed this decision in the apex court. Additional Solicitor General K.M. Nataraj, on behalf of the centre, argued that since the notification was issued on February 16 last year, the court must treat it as being in existence with effect from midnight February 16th. A Delhi court has remanded former JNU student Umar Khalid to judicial custody till October 22nd in connection with the Delhi riot case. Khalid was arrested by the Delhi police on September 13, pursuant to FIR filed under the Unlawful Activities Prevention Act in connection with the riots that broke out earlier this year. Khalid was virtually produced before Judge Amitav Rawat, Additional Session Court, Karkarduma, after his 10 days police custody ended today. Delhi police sought a direction from the court to send Khalid to judicial custody. After the order, Khalid requested the court to allow him to meet his parents and also carry his spectacles and a book to jail. The court thereafter asked him to move an appropriate application for direction to carry his spectacle, etc. to jail. It is the prosecution case in that the Delhi riot were a part of a premeditated, deep-rooted conspiracy which was hatched by Khalid and his associate from various organizations. In furtherance of the conspiracy, police has claimed Khalid gave provocative speeches asking citizens to come out on the street to protest and thus spread the propaganda about minorities in India being persecuted. Observing that the conduct of the person invoking Article 226 of the Constitution of India was a relevant factor, the Delhi High Court yesterday questioned Mehul Choksi if his demand of pre-screening a Netflix show, which could even be considered by a writ court. A division bench of Chief Justice D.N. Patel and Justice Pratik Jalan was hearing Choksi's appeal against an order dismissing his petition seeking a pre-screening of Netflix docu-series Bad Boy Billionaires. A single-judge bench had dismissed Choksi's writ petition on the ground that the same was not maintainable on account of existence of an alternate remedy before a civil court. Choksi has sought a preview of Netflix docu-series Bad Boy Billionaires, apprehending that it would infringe his right to fair investigation and trial. Appearing for Choksi, Advocate Vijay Agarwal vehemently argued that the matter should be remanded back to the single judge for a decision on the merits of the writ petition. When I knock the door of a constitution court, it will not show me the door. A right is guaranteed to me in the same book which gave birth to this court, he said. The court, however, clarified that the conduct of the party invoking writ jurisdiction was an important factor, remarking that reality is stranger than fiction. Advocate Agarwal said that Choksi had left India for his medical treatment before the registration of any criminal case against him. Choksi left for New York on 4th of January 2018 and took oath of allegiance in Antigua on January 15, 2018, and the CBI FIR was registered only on January 30, 2018, he informed. Expressing its displeasure over bogus public interest litigation, the Delhi High Court today said that petition in PILs must come after doing their homework. A division bench of Chief Justice D.N. Patel and Justice Pratik Jalan remarked everyone is a champion of bogus PILs, all blackmailing types of PILs. The court was hearing a PIL alleging mushrooming of illegal hookah bars in the national capital. The petitioner sought a direction to the Delhi police and municipal authorities to inspect and take action against such illegal hookah joints. On being informed that the petitioner was a freelance court clerk, the court questioned as to what interest did a court clerk have in hookah bars. I want to know if this is the case where the client approached the counsel or the counsel approached the client. For a court clerk to suddenly come like this, the whole situation with the PIL. What is the history with the working in this field? What is the source of knowledge? The court asked. The petitioner explained that the petitioner was around South Delhi and he himself noticed that several hookah bars were being operated in violation of the law and the order issued by the Delhi government. The court, however, pointed out that the petition contained only general allegations without reference to any specific illegal hookah joint. Stating that the PIL would be dismissed with heavy cost, the court remarked PIL petitioner has to do their homework. All are super government and all are super police. The court said that the matter deserved to be dismissed with a heavy cost. However, keeping in mind the present pandemic, the same was not imposed. The Delhi High Court has asked the Commissioner of Police Delhi to call reports from all the police stations of honey trap extortion cases and file a report to this effect within 4 weeks. The bench of Justice Suresh Kumar Kait further directed that if the Commissioner of Police Delhi feels that similar type of incident have taken place in Delhi in the year 2020, he shall issue standing orders to all the concerned police stations that action may be taken as per the law. However, without harassing such person alleged accused therein, the bench was hearing a petition filed by the petitioner under Section 438 CRPC, read with Section 482 CRPC for grant of pre-arrest bail to the petitioner. It was an alleged case of honey trapping. The court opined in that though acceptance of allurement is not justified, at the same time, allurement advance for extortion of money is also not acceptable. After pursuing the photographs and chats which were annexed with the present petition, the court remarked, it seems to be the allurement on the part of the complainant and petitioner got trapped therein. However, without commenting on the merits of the prosecution case, I am of the view that the petitioner deserves protection from this court. Accordingly, the SHO-IO concerned was directed that in the event of arrest, the petitioner applicants shall be released on bond on his furnishing a personal bond in the sum of 25,000 rupees. The Delhi High Court directed the central government to consider the complaint filed by Youth Congress Secretary Ambrish Ranjan Pandey against Republic TV for communal reporting of Palghar mob lynching incident. The bench of Justice Naveen Chawla has directed the Ministry of Information and Broadcasting to consider the petitioner's complaint and take a decision on it within 4 weeks. The petition filed through Advocate Jobby P. alleged that the channel made repeated attempts to paint the event of mob lynching at Palghar, Maharashtra into a communal event, creating fear in the mind of common people. The entire show was aimed at promoting enmity between different religious groups by communalizing and politicizing the incident, it said. It was further alleged that migrants gathering at Bandra in Mumbai were given the tag of gigantic conspiracy in another program by the same media house. It was pointed out that the self-regulatory body, National Broadcaster Association, does not have the jurisdiction to probe Republic TV channel as it is not a member of said organization. Hence, a direction was sought against the ministry to consider the complaint and pass appropriate orders therein. Pandey contended that the channel had violated the rules of program code prescribed under the cable television regulation and also the uplinking and downlinking guidelines issued by the ministry. She has therefore sought for a direction upon the ministry to take appropriate action against the channel and also frame rules in the nature of Cable Television Network Rule 1994 to formulate a statutory body which shall adjudicate the complaints against television channels within a predetermined limitation period along with appellate and other redressal mechanism. The Punjab and Haryana High Court has ruled that through the state government has an absolute right to retire and employ in order to weed out dead wood from the government services. A conclusion on this aspect has to be based on subjective satisfaction about the employee's performance during service. The bench of Justice Daya Chaudhary and Meenakshi Mehta emphasized that the employee's record from the last 10 years was especially crucial to deciding whether to compulsorily retire an employee or not in the public interest. The judge were hearing an appeal made by Tehsildar. The appellant had challenged an order dated April 1st, retiring him prematurely after the age of 55. A single judge of the High Court had earlier dismissed his plea against the compulsory retirement. Referring to the state policy allowing for premature retirement, the bench pointed out that the objective of the said policy was for providing clean administration, improving efficiency, strengthening administrative machinery at all levels and weeding out dead wood where integrity was doubtful. As per the state's retirement policy, an employee could be prematurely retired once he attains the age of 55 or after his completion of 20 years in service. The court observed that the error in mutation was evident and not a deliberate act done for consideration. Apart from this, there was no other material in the Tehsildar's service record that warranted his premature retirement. The Bombay High Court, while hearing Kangana Ranaut's plea against MCGM's demolition of her bungalow turned office at Pali Hill, Bandra, observed that the court cannot leave the party demolished property as it is, and the bench will begin hearing Kangana's case tomorrow. After the counsel for MCGM officer Bhagyavant Late sought more time to file an affidavit, division bench of Justice S.J. Kathawala and Justice R.I. Chagla observed, "We cannot leave the partly demolished house this way it is. We will start hearing the petition tomorrow. You need more time here, but otherwise you are very fast." Bhagyavant Late is the designated officer of the municipal corporation who, along with other officials, carried out the demolition at actor Kangana Ranaut's bungalow at Pali Hill, which she turned into an office. He was impleaded as a party in the case along with Rajya Sabha MP Sanjay Raut. Appearing on behalf of Sanjay Raut, Advocate Pradeep Thorat also sought more time to file affidavit as his client is in Delhi to attend the ongoing parliament session, granting time to both Raut and Late till next Tuesday to file their affidavits Court observes since monsoon has started and the bungalow is partly demolished, hearing cannot be delayed any further. So we will now allow the petitioner's advocate to begin arguments tomorrow. The matter will come up tomorrow, that is Friday at 3 p.m. Last Tuesday, the court allowed Rajya Sabha MP and Shiv Sena chief spokesperson Sanjay Raut to be added as party to the proceeding, as the actor had relied upon a video of Raut allegedly abusing her while alleging malice in the action taken against her in the Municipal Corporation of Greater Mumbai. And that's all for this Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.